can perhaps just place himself on record.
I confirm that I appear for Ms. Gilby.
Just get your name again?
John Riley.
Riley, as in R-I-L-E-Y.
That's correct.
We have been presented with a written statement by the witness, Mr. Commissioner, that's been prepared by Mr. Riley and the witness. She is ready to take the prescribed oath.
Do you have the signed version?
Yes, we do have, Mr. Commissioner.
Morning, Mrs. Hamildin.
Morning, Mr. Commissioner.
Do you have any objection to taking the oath or affirmation?
No objection, Mr. Commissioner.
Well, which one shall it be?
I'll take the oath.
Thank you. Do you swear then that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth? Raise your right hand and say, so help me God.
So help me God.
Thank you. You may be seated.
Okay.
Thank you. Mrs. Hamildin, just for the record, you are still in the employ of AO Technologies.
That's correct.
What is the position you presently hold in that company?
I am the executive responsible for business transformation.
Is it correct that you were the chief financial officer of this entity?
That's correct.
Till when?
Up until January 2019.
After the departure of Mr. Hardy, the former CEO, were you appointed as the acting CEO?
I was.
When?
I was appointed on the 23rd of August 2018 up until December 2018. I'm not sure of the correct date.
And then you resigned as the acting CEO and the CFO.
That's correct.
We'll come to that. For the record further, you are here testifying under a subpoena from this Commission of Inquiry.
That's correct.
And you are represented by your attorney, Mr. John Riley from Cape Town.
That's correct.
Now, before we start, can you please tell the Commission about yourself, where you were born, where did you study?
I was born in Port Elizabeth. I completed my BCom at the Nelson Mandela University in 2001 and thereafter obtained my honours from UNISA in 2002. I commenced my articles with PricewaterhouseCoopers in Port Elizabeth in 2002 and completed that in 2005.
Thank you. Thank you. You can then proceed with your statement from paragraph 2.
I have been subpoenaed to testify at the Commission of Inquiry into allegations of impropriety into the Public Investment Corporation. I understand that the Commission is mandated to look inter alia into alleged impropriety regarding investment decisions by the PIC in media reports in 2017 and 2018 contravened any legislation, PIC policy or contractual obligations and resulted in any undue benefit for any PIC director or employee or any associate or family member of any PIC director or employee at the time a director or employee of the PIC. I have been requested to produce all financial records, in particular payments made to third parties from the funds invested by the PIC. After I received the subpoena, I instructed my attorneys of record to request the evidence leader of the Commission to provide me with further details about what precisely I was required to testify about. My attorney of record was then provided with a list of questions that I was required to respond to. For the sake of convenience, I do not propose to respond to the questions in any particular order, and I deem it necessary to provide some background in an attempt to place the events in chronological order as they occurred leading up to the listing of IO and certain events which occurred thereafter. Although I have been requested to produce all financial records, in particular payments made to third parties from the funds invested by the PIC, I am unable to produce such financial records due to the fact that I no longer have access to such records. I will nevertheless attempt to provide such detail as is in my personal knowledge. I moved to Cape Town in 2006 and joined Secunjalo Investments Limited, which later became African Equity Empowerment Investments, AEEI, in 2007 as the Group Financial Accountant, and was subsequently promoted to Group Financial Manager, where I reported to Khalid Abdullah, who was the Chief Financial Officer. In 2009, I joined Health System Technologies as their Financial Manager. In about 2011, I took on the role of Group Financial Manager at Secunjalo Technology Solutions Limited, which subsequently became IO Technology Solutions Limited. I was appointed to the IO board in 2014 and was thereafter appointed in 2017 as the Chief Financial Officer prior to the listing. I was appointed as Acting Chief Executive Officer after the resignation of Kevin Hardy in August 2018, whilst at the same time performing my role as CFO. I stepped down as CEO in December 2018 and as CFO in January 2019. At the same time, I also resigned from the IO board. I currently hold the position of Executive Business Transformation within IO. AEEI was the majority shareholder of IO immediately prior to the issue of the BEE consortium shares and listing, holding 80.03%. Secunjalo Investment Holdings Limited, Secunjalo, is the majority shareholder of AEEI. AEEI holds a 30% stake in British Telecom South Africa and has representation on the board of BTSA.
Sorry to interrupt you there. Who are the representatives on the board of BTSA? Who were the representatives?
Yeah, I'm not sure who are the representatives, but to my knowledge, Khalid Abdullah and Dr. Iqbal Survey were previously on the board of BTSA. HST is a wholly owned subsidiary of IO.
Sorry, can I ask there, and it's perhaps to you, Advocate Libba. This again reflects the different entities within the group. And at Dr. Survey's appearance before the Commission, we had requested a full organogram of all the entire group entities, related parties, ownerships, and PIC flows of money. As far as I'm aware, we have not received that yet.
Through you, Mr. Commissioner, it's absolutely correct. I have also sent a follow-up email to IO and Dr. Survey requesting this information, and if we don't receive it by the end of business tomorrow, I will have no other option but to subpoena the CEO to come and present that evidence.
HST is a wholly owned subsidiary of IO. AEEI had for a few years prior to listing intended to list IO separately on the JSE, and this had been communicated to the market. In 2016, IO had acquired businesses at good multiples owing to the new BEE ICT sector codes, but sourcing bank funding was challenging.
Can you just explain for the benefit of the Commission what exactly is meant by acquiring businesses at good multiples?
Acquiring businesses at good multiples, the multiple referred to is basically a multiple of profit. So a good multiple would mean that you're buying it at a low multiple, essentially.
Thank you.
In November 2016...
Sorry. Yeah. Just a question, Mrs. Kamaldeen, yes. Good multiples, would that be PEs, like PEs of 3 or P of 4, somewhere there? Were those kind of multiples that the businesses were bought at? Were those the kind of multiples that those businesses were bought at?
I understand, Mr. Commissioner. I'm not sure which multiples those were specifically bought at, but generally between 4 and 6.
Yeah, thank you.
In November 2016, the amended BEE ICT sector codes were issued, which encourages procurement from black-owned businesses where black ownership is at least 51% and black female ownership is at least 30%. This provided IO with a competitive advantage over other similar companies in the ICT sector. In order for IO to reach the scale required, it would, however, need to acquire businesses with existing capability and intellectual property. At this time, Sasol was a client of BTSA, and Sasol had been negatively impacted by the change in the BEE codes referred to above. At that time, Hardy held the position of CEO at BTSA. It is my understanding that Sasol had requested their ICT providers to relook their ownership models in order to maximize their preferential procurement scores on their BEE scorecard. BTSA then commenced discussions with AEEI to develop a structure that would service these clients. IO was selected as the vehicle which would be used for this purpose. IO would market and sell the products and services offered by BTSA and all other companies in which IO had a shareholding, and procure from such ICT companies. The idea was that IO would operate as an independent entity with its own resources, but would need funding. This funding was to be obtained by listing on the JSE. BTSA obtained a legal opinion from the law firm Edward Nathan Sonnenberg on this issue to ensure that there was no risk of fronting. I am advised that ENS concluded that the proposed transaction, as they understood it at that stage, did not constitute a fronting practice as contemplated in the BBBE Act and or did not contravene the BBBE Act, the BEE codes, or the ICT code, provided that certain of the recommendations made by them in their opinion are implemented. This opinion is available for inspection should it be required.
Can I just, Mr. Commissioner, will the Commission advise whether that opinion is necessary, but it is available?
My understanding was that the alliance agreement between IO and BTSA was intended to be the basis for the terms of the agreement, in terms of which BTSA would become a subcontractor to IO in servicing Sasol. It is necessary to point out that this alliance agreement must be distinguished from the subscription of shares by IO in Kilomix, which holds a 30% stake in BTSA.
Sorry, Ms. Hamildin, if I could just ask you to expand on that last point about the alliance agreement and the stake in Kilomax as to what their current status is. Are they in play? Are they in force? What exactly is the position as far as you're aware?
Thank you. As far as I'm aware, the alliance agreement is still in play. So IO is currently servicing Sasol as a customer, and BTSA is still a subcontractor to IO in terms of this alliance agreement, as set out in this alliance agreement.
And the Kilomax? Is that still at the 30% as it was?
It's still as it was, Mr. Commissioner. The shares are still held via Kilomix by AEEI. So IO did not purchase the stake in BTSA. I started to attend listing meetings around May 2017. The purpose of the meetings was to achieve the listing of IO on the JSE by the end of 2017. Thereafter, as time went by, the listing team would meet on a weekly basis, and this included members from AEEI Corporate Finance, Weber Wenzel, PSG, and BDO. My involvement in the listing process was mainly to coordinate the input from the respective parties for inclusion in the pre-listing statement. The rationale for the listing is set out in the PLS and can be summarized as follows. Raise capital in order to fund the rollout of the BTSA strategic relationship. Raise capital in order to fund the BTSA subscription of shares. Raise capital in order to fund the IO acquisition pipeline, and allow IO to use listed scrip to fund future acquisitions.
Sorry, in relation to that rationale, which of those four elements, if any, were actually given effect to after the listing?
So the first one, the BT strategic relationship. As explained, BT is a subcontractor to IO on the Sasol contract, and the third one, the IO acquisition pipeline.
Both, is BTSA fulfilling that function as a subcontractor to anything else other than SASOL?
Not at this stage,
Not
no.
at this stage. And then the question of the fund, the acquisition pipeline, you refer to some of those acquisitions later in your statement. Is that what you're referring to here?
That's correct, Mr. Commissioner.
Okay. Thank you.
To the best of my knowledge, the BTSA team were already in discussions with SASOL in 2017, and a request for proposal was to be submitted to SASOL in January 2018. Hence the urgency to obtain funding to ramp up for this and future projects. PSG Capital, PSG, was engaged by Abdullah to draft and/or comment on the listing documents, project manage the listing, advise on the JSE listing requirements, and submit all documentation in relation to the listing to the JSE.
Can you just again tell the Commission who exactly is Abdullah?
Khalid Abdullah is the CEO of AEEI, but at the time he was also a board member of IO. As appears from the PLS, the fees payable to PSG for their services amounts to 14.5 million. I attach the letter of appointment dated 29 September 2017, which sets out the full detail of PSG's mandate as well as how their fee of 14.5 million is made up and arrived at. So this is attached as NG1.
Just a question here. In terms of PSG and AEI, who are supposed to do the capital raising? Were they both supposed to do it or one or the other? The actual, capital raising, going to road shows and,
Mr. Commissioner, it was my understanding at that point that both of them would be involved in capital raising.
And who finally raised the capital, the 4.3 or the capital raised?
Mr. Commissioner, that came via AEEI Corporate Finance. As appears from the letter, I was not involved in these negotiations. I did, however, independently compare this fee against the fee charged to Premier Fishing and accordingly formed the view that the fee charged by PSG was not unreasonable, considering the amount of capital to be raised.
I'm sorry to interrupt again. The reference to Premier Fishing, was that also a listing that was done previously?
Yes, Mr. Commissioner, Premier Fishing is part of the AEEI group of companies, and that entity was listed earlier the same year.
Thank you.
AEI Corporate Finance was mandated to act as IO project manager, corporate advisor, and book runner to IO in relation to the listing because the IO executives were advised by Abdullah that AEI Corporate Finance was best suited to deal with this issue because of their experience in these matters. AEI Corporate Finance was also responsible for preparing the share valuation.
Sorry, can I just ask in relation to that, when they're referring to their experience, would that be referring to Premier Fishing?
Yes,
And
Mr.
would that be
Commissioner.
their only experience of listing?
Yes, Mr. Commissioner, to my knowledge, that would be their only experience with listing.
And AEI Corporate Finance obviously is part of the related party entities within the second JALO grouping.
That's correct, Mr. Commissioner. As appears from the PLS, AEI Corporate Finance would earn a fee of 57.7 million for their services. I was not involved in the determination of the fee. Malik Sali, as the head of AEI Corporate Finance, was responsible
Can I ask something? And if you can answer, please do. If not, it's fine. AEI Corporate Finance negotiates with AEI Group Company. Surely sort of really like one company talking to one another. Is there no way in which there could have been some Chinese walls about that
I'm not in a position to really comment on that, Mr. Commissioner, because I wasn't involved in the determination at the time, in the negotiation at the time.
Okay.
But I think for reference, again, Advocate Libber, it might be useful to know whether this was a reasonable fee and whether there's a related party issue here about independence of advice, of fundraising, of fees charged, and whether, in fact, this would not be a breach of governance, and perhaps any other rules about who advises whom in a listing.
Noted, Mr. Commissioner.
Malik Saleh, as the head of AEI Corporate Finance, was responsible for preparing the forecasts, which was presented in the PLS, and this was reviewed by myself. The revenue was projected to increase by 825%, and this was premised on the following assumptions, which is clearly documented in the PLS. The main driver for this increase was the existing BTSA customers, which would transition across to IO. IO was targeting an increase in market share of between 1% and 2% for the periods forecasted, owing to its superior BEE credentials. And the existing IO subsidiaries would achieve organic growth due to the working capital funding which IO would provide. It is necessary to mention in this regard...
Just a question again here. Please, if we can answer. You know, I asked this question before. Growing revenue by this amount within a year, I mean, that's a tall order, you know. What were you thinking then when you saw this kind of projections?
Okay. Thank you, Mr. Commissioner. I think the next paragraph answers that question. Can I read it first? Thank you. It is necessary to mention in this regard that Hardy provided us with the BTSA customer information and market data, and the forecasts were based on this information. He also provided a list of customers which was to be targeted for acquisition purposes, the details of which are contained in the PLS. The fact that Hardy was prepared to leave BTSA and join IO as CEO gave me great comfort, as I understood that he had long-standing and good relationships with the BTSA customers and extensive experience and respect in the ICT sector. We were all excited about the opportunity to build the largest black ICT company listed on the JSE. So,
If I can interrupt you here, I'm sorry. You have read the statement of Mr. Hardy. Is that correct?
I have, Mr. Commissioner.
And you, I suppose you have also listened to his testimony before this commission.
I have, Mr. Commissioner.
As I understand, and if I remember correctly, his evidence was that it was a very high target, but he was also optimistic that it could be achieved.
That's correct, Mr. Commissioner. We were all optimistic that it would be achieved. From my perspective, the comfort came from Mr. Hardy providing us with the customer information that would transition across into IO, etc., etc.
But crucial and central to this high expectations was the successful bringing on board BTSA.
That's correct, Mr. Commissioner.
Just a question there. I can understand that, but you know, to buy a company takes 6 to 12 months. You know, valuations, negotiations, shareholder agreements. I mean, and you are buying many companies. I mean, surely could you do this in 1 year? I mean, this sounds like blue sky to many of us, you know.
Mr. Commissioner, important to note is that those acquisitions were never factored into our forecasts. Our forecasts were mainly capturing market share and the BTSA customers which would transition across. So those acquisitions were never factored into those numbers. Okay.
But even, I mean, capturing market share, it's a very difficult thing. I mean, in terms of meeting customers, they must agree to these things. Even that is quite difficult to do it within a year. Would you comment on that, if you want?
Yeah. Other than to say noted, Mr. Commissioner, it was a difficult task, and we knew that. Yeah. But we were optimistic that we would be able to achieve it.
Yes.
At the time.
Which, in some ways, the optimism might mean blue sky thinking. You know.
Perhaps.
Yeah. Yeah, all right. Let's leave it. That's fine.
Can I just ask you, in the last point under 24, the existing IO subsidiaries would achieve organic growth due to the working capital funding. That's assuming the working capital funding came from the listing,
That's correct, Mr. Commissioner.
and the existing IO subsidiaries, can you identify or indicate which those were?
Certainly, Mr. Commissioner. At the time of listing, the subsidiaries were Health System Technologies, which is HST, Pulling, Headset Solutions, Afrazar, Digital Matter.
Can you just repeat that again? IOs?
Subsidiaries at the
Subsidiaries,
time,
HST, Puleng,
Headset Solutions, or Kalula Communications is the legal name of the entity.
sorry, can you just spell that for me?
Kalula, K-A,
Okay.
yeah. Kalula Communications, Afrazar,
Yeah.
and Digital Matter.
Digital?
Digital Matter. Matter.
Okay. And what has happened to those entities subsequently?
They are still part of the IO group of companies, Mr. Commissioner.
And functioning well?
Yes, Mr. Commissioner. These revenue targets were not achieved due to a breakdown in the relationship with BTSA. Negative media reports about IO negatively impacted on our ability to attract new customers or generate any additional business from SASOL, and the reputational damage to IO had a further negative impact on ability to successfully make the intended acquisitions.
Are you aware of what caused, or do you have a view on what caused the breakdown of the relationship with BTSA, given the point made above that the projected revenues were dependent on an amicable working relationship of whatever form with BTSA? Because then you've only got the alliance agreement in place. If you could just comment on the breakdown.
Certainly, Mr. Commissioner. It is my understanding that the reason why the relationship broke down is because there was certain information related to BTSA which we had disclosed in our PLS without the consent of BTSA.
Before you move, two questions here. Mr. Hardy, if I can recall, he actually said without BTSA, there is no IO. Do you think so, or don't you think so about that?
It's difficult to answer that one, Mr. Commissioner, because initially we would have needed BTSA in order to fulfill the SASOL contract, and certainly we would have needed BTSA for all the other customers that were to transition across. But the intention was to acquire other businesses, and we had businesses in our pipeline, and those businesses could also be used to service prospective clients. But obviously that would take time.
And then the other one is the PIC, I think it was Victor Siani. They were struggling to get the BTSA financials. Do you know why that was so? What was the issue there? Why couldn't the PIC get the financials?
Yes, Mr. Commissioner, my understanding is that the reason why we couldn't disclose the financials to them was because of confidentiality. We needed BTSA's consent before we could release the information. That was my understanding, though I wasn't directly involved in the issue.
And why couldn't you get the consent? Do you know?
I'm not sure, Mr. Commissioner.
Yeah.
I wasn't involved in that at the time.
Okay.
You heard the evidence of Mr. Hardy in this regard, and also in his statement, and that is that there was a breakdown in the relationship with BTSA and AU. Is that correct?
That's correct, Mr. Commissioner.
Is that perhaps the reason why you couldn't obtain the permission from BTSA to disclose the financials?
I'm not sure, Mr. Commissioner. Abdullah was responsible for the BEE consortium share issue. Between 20 and 27 November, Abdullah provided me with a list of entities that would potentially participate in the BEE consortium share issue. He advised that the rationale was to ensure the retention of broad-based black ownership within IO.
Ms. Advocate Lubber, I think we had asked for that list before as well, and I don't think that we have received that.
That is absolutely correct, Mr.
Can we follow up on that as
We
well?
do.
On the 27th of November 2017, I was informed by Abdullah that our attorneys for listing purposes had changed due to the fact that we wanted to give a smaller black firm exposure. TGR attorneys was appointed and I was requested to update the PLS accordingly.
Sorry, just on that matter, had TGR attorneys been used by any of the Secondjalo group before, and was there any related party connection there?
Yes, Mr. Commissioner, to my knowledge, I don't really have knowledge on that issue. It was the first time that I had heard of TGR attorneys, and to my knowledge, they are not a related party. But I don't have access to all the information in the broader Secondjalo group.
My information, Ms. Khamaldeen, is that notwithstanding this appointment of TGR attorneys, Weber Wenzel carried on doing the work for the listing. Do you know anything about that?
I'm not aware, Mr. Commissioner.
Are they still, is TGR still used by AO in any other matters?
Not to my knowledge, Mr. Commissioner.
Thank you.
On the same date, the 27th of November 2017, AEEI released a SENS announcement informing the market of the intended BEE consortium share issue. The intention was to issue 31,960,000 shares at R1.50 to various broad-based empowerment consortiums.
Question there. Do you know if a valuation was done in terms of issuing these particular shares to BE groupings? Was the evaluation done, or Mr. Abdullah just decided to put a price?
I'm not sure, Mr. Commissioner. I'm not sure how they arrived at the price of R1.50 per share. This BEE share issue, along with the listing of IO, would constitute a Category 1 disposal by AEI in terms of the JSE listing requirements, and therefore required the approval of the AEI shareholders by way of a general meeting, and a circular was to be issued in this regard. The Social Entrepreneurship Foundation was listed in the circular as one of the consortiums which would benefit from the share issue, but to my knowledge, they were not on the final list of shareholders who were eventually allocated shares.
Before you continue, can you just elaborate on that? Do you know who Social Entrepreneurship Foundation, who that is?
I'm not aware of who the Social Entrepreneurship Foundation is. I have no knowledge of who the directors and shareholders of that entity are.
Now, you mentioned the final list of shareholders. Where did you get that list?
Mr. Commissioner, the final list of shareholders who were allocated shares was provided to me by Dr. Iqbal Survey.
Was it in all respects similar to the one that you received from Mr. Abdullah?
Mr. Commissioner, there were some differences.
Do you have the original supplied by Mr. Abdullah still?
Yes, I do, Mr. Commissioner.
Are you prepared to provide the Commissioner that list?
Yes, Mr. Commissioner.
And do you have the lists, the final lists supplied by Dr. Survey? Do you have that still available?
Yes, I do, Mr.
And you
Commissioner.
can provide that to the Commission? Because we've asked for that, but it has not been provided to the Commission, but you say you can provide it.
Yes, Mr. Commissioner. I have no knowledge of who the directors and shareholders of the Social Entrepreneurship Foundation is. According to the best of my knowledge, some of these BEE consortium shareholders were funded by Dr. Survey via Premier Fishing. I no longer have access to the financial records and do not recall the exact amount funded.
No, go on.
Funded via Premier Fishing. I don't understand that. How can Premier Fishing fund PE groups in another company?
Mr. Commissioner, the payment entered the IO bank account from Premier Fishing. It was transferred from Premier Fishing to IO, but as I understand it, it was funded by Dr. Surve and he returned the funds to Premier Fishing.
Come again slowly. Come again slowly there.
Sure. Mr. Commissioner, the transfer was made into the IO bank account from Premier Fishing, but as I understand it, Dr. Iqbal Surve repaid Premier Fishing.
So the Premier Fishing bank account was used to purchase shares, IO shares for BE groupings.
Yes, Mr. Commissioner.
I mean, Premier Fishing bank account is being used for something which is not business related to the Premier Fishing group.
I
You
understand.
are an accountant, I'm sure you.
Yes, Mr. Commissioner.
Like, am I correct that that shouldn't be done?
That's correct, Mr. Commissioner. At the time, though, my understanding was that the funds were paid back to Premier Fishing by either Dr. Surve or a related entity.
Yes, I do understand that it can be repaid by Dr. Seven or that, but I mean, when you do the audits and say, this payment, what was it for? Is that proper? Is that like a proper thing to do?
I can't comment on that, Mr. Commissioner.
You are an accountant, I'm sure you would know these things.
Yes, sir.
You can't comment?
No, I can't comment on
Okay,
that.
all right. Okay.
Mr. Commissioner, I suppose that the next question from the Commission will be the particulars of the amounts involved. We will follow that up and we'll provide the Commission with that information.
But in addition, who authorized the payment from Premier Fishing? Because that is the issue. You can't just authorize. It's got to be somebody from that company that authorizes it, and therefore it has to be a valid transaction.
It is
So
noted.
who authorized that, and then what the timeline was between payment, the return payment, or the reimbursement, if you want to put it that way, because that's what it sounds like, the reimbursement of the funds used. And why would you have done that via a company if you're going to reimburse? You could have just done it directly.
It is noted. Thank you, Mr. Commissioner.
The general meeting took place on the 18th of December 2017, and the above was approved by the AEI shareholders on this date. The IO listing received formal approval from the JSE on the 12th of December 2017, and a SENS announcement was disseminated on the 13th to this effect, as well as announcing the BEE consortium share issue. The BT
I just want to go back to that point, Dr. Libber. Can we also check if this was the only such transaction, that where it was used as a piggy bank for Premier Fishing?
It is noted. Thank you.
The BTSA Alliance Agreement was negotiated mainly by Kevin Hardy, though I had reviewed the agreement and provided input. This was also signed on the 12th of December 2017. I had left to spend the Christmas holidays with my family in Port Elizabeth on or around the 15th or 16th of December, as my dad had been ill for some time. I flew from PE to attend the listing function at the JSE on the 21st of December 2017.
Before we carry on, was that a function on the floor of the JSE?
That's correct, Mr. Commissioner.
Can you remember who were present from the PIC?
Mr. Commissioner, the only person I recall being there was Dr. Dan Majikla. I didn't recognize any of the other faces.
And the top structure of AO and AEI, I suppose, were all there?
That's correct, Mr. Commissioner.
Thank you.
On the 18th of December 2017, a SENS announcement was disseminated indicating that the IO shares had been oversubscribed by 1 billion rand. I was not involved in the share allocations, as this was handled by AEI Corporate Finance. I was informed that the full allocation had been made to the PIC instead. I subsequently obtained the following information from AEI Corporate Finance, which confirms that the IO shares were oversubscribed by 1,005 million, which is made up as follows. Miramar Investments, 160 million, Capital One Investments, 215 million, Selwyn Roy Lewis, 430 million, Three Laws Capital, 200 million.
Sorry, can we just stay with that? Sorry, go. Can we ask then, in relation to these four entities, we do know Three Laws Capital is owned and controlled by Sekunjalo, as you're saying, in point 38, and that has come up before. But can we find out why there was no allocation to these other three, to all four entities? Did they not want to take up their shares? Why would they have then subscribed? What were what were the reasons given for non-allocating to them and giving everything to the PIC? Did the PIC actually insist on taking the entirety of the share allocation? And are there any related party transactions or connections between these four companies with the Sekunjalo Group? The question of who the directors are, what their businesses are, who exactly are these entities, as it does raise question marks of being part of a commitment to take up shares, and then suddenly it all goes to the PIC at a particular price.
Thank you. It is noted, Mr. Commissioner.
Three Laws Capital is an entity owned and controlled by Sekunjalo. I am not aware whether any of the other entities are owned or controlled by Sekunjalo or Dr. Survey. In response to the question about where the 43 Rand per share came from, what valuation was done to get the 43 Rand per share, and whether the BTSA historical numbers were in my possession, and what they indicated about the future revenues, I must point out that these matters were all dealt with by the AI corporate finance team. I am accordingly not in a position to provide details about where the 43 Rand per share came from and what valuation was done to get to this price. I do not recall having access to the BTSA historical numbers.
Before you continue, I have presented you this morning, before you started your testimony, with a document It is an email from Mr. Malik Sali dealing with the AO pre-listing, and the email is dated September 3, 2017. It is sent at 7 o'clock that evening. It is sent to Mr. Hardy, to yourself, to Mr. Khalid Abdullah. It is copied to him. Mr. Commissioner, I've presented the Commission with a copy of this. I trust it is before you. And attached to this email is the minutes of a meeting with the AO listing team held at Claremont offices on the 8th of August 2017. According to the minutes, the following people were present at this meeting: Dr. Survey, Salim Young, Khalid Abdullah, Radansha Nok, Jabulo Jiki, and yourself. There was apologies from Mr. Sali. Now, what I want to know from you, have you received such an email?
Mr. Commissioner, I would have to check whether or not I'd received such an email.
Can you recall a meeting minuted in this document stating the minutes of the meeting on the 8th of August?
I do recall such a meeting, Mr. Commissioner.
And you were present?
That's correct, Mr. Commissioner.
And the meeting was dealing with the listing and trying to get to a valuation of AO and the share price of AO. Is that correct?
I can't recall, Mr. Commissioner.
Well, if you look at the minutes, is that not what is stated in the minutes? The purpose of this question is not to get you into trouble, but Dr. Survey testified under oath before this commission that he was not involved in the pre-listing matters. They had very competent people dealing with that. They were sitting behind him that day in the commission. But it appears from this that he was indeed actively involved and attended meetings on the pre-listing values. Is that not correct?
Mr. Commissioner, the only meeting which I attended where Dr. Survey was present was that one meeting. I don't recall him being present at any other listing meeting.
Okay.
I can't remember the exact details of what was discussed on the day, though.
Did you discuss anything about the pre-listing with Dr. Survey before the listing?
No, Mr. Commissioner, I did not.
Thank you. You can please proceed.
I was not directly involved in the 990 million valuation arrived at for the 30% held by Kilomix. What I do know is that in accordance with the JSE listing requirements, the investment was required to be independently valued by a JSE-approved valuer. Questco Corporate Advisory was appointed for this purpose. I attached the independent expert opinion in respect of the subscription by IO of new shares in Kilomix constituting 99% of the issued shares in Kilomix as Annexure NG2. In regard to the question about whether or not the BTSA alliance agreement was sufficient to allow IO to achieve its objectives.
Sorry, can I just ask you a question on paragraph 37? Are you aware that when you apply for JSE shares in a listing, probably there's a formula to allocate shares, when people sign subscription forms, once it goes through, you have applied for shares and they would normally then be allocated via a formula. Did we have that in the IO listing, or because one would presume then that all the parties that applied for this would get allocated shares?
Mr.
No?
Commissioner, yeah, I wasn't involved in the allocation of shares. That was handled by AEI Corporate Finance, so they would be best positioned to answer that question.
Okay, thanks.
In regard to the question about whether or not the BTSA alliance agreement was sufficient to allow IO to achieve its objectives, rather than to sell Kilomix's 30% to IO, I respond as follows. I was personally not opposed to the deal, as I felt that the 30% ownership would give us representation on the BTSA board and allow us to cement the relationship with BTSA. We would also be able to equity account for the 30% of the profitability of BTSA, which would be to the benefit of the IO shareholders. The IO executives were, however, concerned about the pricing of the deal and were concerned whether the PIC would be agreeable to the transaction, as the funds would ultimately flow to AEEI. Hardy was responsible for addressing these concerns. After the listing on the 21st of December 2017, I returned to PE, and on the 22nd of December 2017, I was instructed telephonically by Abdullah to transfer 35 million to Three Laws Capital and a further 35 million to Sekunjalo Capital. I requested that he send me this instruction in writing, as I was concerned about the payments because I felt that board approval would be necessary in this instance.
I'm sorry to interrupt. Just to make it clear and for the record, this is transfers from the AO account into those other two entities.
That's correct, Mr. Commissioner.
And it is money coming out of the investment by the PIC.
That's correct, Mr. Commissioner.
Can we just go back a second to the previous paragraph? The IO executives were concerned about the pricing of the deal, which is the one element, and were concerned whether the PIC would be agreeable to the transaction as the funds would ultimately flow to AEEI. Why would they flow to AEEI when it's an AO capital raising?
Mr. Commissioner, I speak there about the acquisition of the 30% in BTSA, which was held by AEEI at the time. So if IO were to purchase those shares, the funds, the 990 million for the purchase of the 30% of shares would be to AEEI. I requested that he sends me this instruction in writing as I was concerned about the payments because I felt that board approval would be necessary in this instance. He subsequently sent me an email with the bank details. After I had received the email, I made the necessary payments. In retrospect, I realized that I erred in making the payments, but did so because Abdullah was adamant that the payments be made. The board subsequently ratified this as an investment with Three Laws Capital, and I signed an investment mandate to this effect.
And this is the same concerns which we raised about corporate governance, that things are done, no board approvals for things, no resolutions, and it just looks like there's a problem, a huge problem in the group companies with corporate governance across the board.
That's correct, Mr. Commissioner. The payments that I speak about here were before the signature of that letter, though, but that's correct, Mr. Commissioner.
What is it of a
Sorry, and did the board ratify the 35 million to Sekunjalo Capital as well, or only to Three Laws Capital?
Mr. Commissioner, the board ratified an investment of 70 million with Three Laws.
So the original instruction of 35 and 35 was changed to 70 to Three Laws?
That's correct, Mr. Commissioner.
Were you at the board meeting?
Yes, I was, Mr. Commissioner.
Can you recall what was placed before the board as the motivation or the reason for this investment into Three Laws?
If I recall, the rationale behind all the investments with Three Laws Capital was to diversify the cash holdings so that we don't have all the PIC funds sitting in one bank account. When Abdullah again...
I think it would be very useful to get the submission to the board about that matter, because it is really, Three Laws is a related party. So you're putting deposits with them to earn interest in a related party matter.
It is correct, Mr. Commissioner, through you. It's exactly why I asked the question, to in fact obtain that
So we can get the board
documentation.
Yeah.
When Abdullah again on 1 March 2018 instructed me telephonically to transfer 400 million to Three Laws Capital, I told him that I was not prepared to transfer this amount without board approval and requested that a resolution be drafted.
Sorry, if I could just ask you again, and I'm sorry to keep interrupting you, but it's really for clarity. This would have been 400 million in addition to the 70 million.
That's correct, Mr. Commissioner. I then discussed this with the other IO executives and informed them of the request, of which we were all uncomfortable.
Sorry, we keep interrupting you.
That's fine.
But we had the testimony of Mr. Hardy and an email confirming that Mr. Johnston from Three Laws Capital had absolutely no say or control of these monies transferred into Three Laws.
They, however, verbally agreed.
Can you comment on that? Do you know anything about it?
Yes, Mr. Commissioner, I think I was copied in on that email, though I was not privy to the conversations between Mr. Hardy and Mr. Johnson.
But you have seen the email where Mr. Johnston complained about the fact that he had absolutely no control over that money.
I did, Mr. Commissioner. They, however, verbally agreed to sign the resolution along with a few other directors. On the 2nd of March 2018, Abdullah sent an email to Salim Young and Hardy in which he motivates why the 400 million should be paid. I attach in this regard Annexure NG3. In response to this email, Young stated that, all good with me, please ensure that there is appropriate reporting to the board or at least the investment committee. I then replied to the email exchange between Young, Abdullah, Sali and Hardy and stated, as per discussion with the executives, we are in agreement to invest with Three Laws, but will need a board resolution approving the transaction.
Before I forget, just to get it on record, Mr. Young, who is now featuring everywhere in your testimony. What is he? Is he a chartered accountant, a lawyer, or what is he doing?
My understanding, Mr. Commissioner, is that he's an attorney.
Thank you.
Since the majority of directors had already approved, I will proceed with transfer and simultaneously request that the resolution be circulated. At that time, I only had verbal approval. The resolution was eventually signed by the majority of the board. We agreed to transfer the funds on condition that it would be returned before our financial year end of 31 August 2018. These funds were repaid by Three Laws Capital on or about 21 August 2018.
Just a question, I mean, looking at this paragraph 43, you were a director in the company in IO. I mean, with all this, corporate governance breaches, were you not worried that if the money get lost somewhere or doesn't come back, that, shareholders can sue you? I mean, these are listed companies. These are not private companies. There are other shareholders, Weren't you worried as a director that you could be sued?
Yes, Mr. Commissioner, we certainly were worried, and that's why we eventually wrote that letter to the board to express our concerns.
Mr. Commissioner, just a household rule. It's nearly 11 o'clock. It's the only witness for today. Would it be acceptable that we do not take a tea adjournment and finish the business of the day?
I think that's preferable.
In July 2018, a round-robin resolution was circulated by the company secretary to invest $1.5 billion with various asset managers in an attempt to reduce risk by diversifying the IO cash holdings.
I'm sorry again to interrupt you. Can you just identify who is the company secretary?
Yes, Mr. Commissioner. At that point, the company secretary was Nobulungisa. I can't recall her surname, Baliseli, I think it is. This email gave me the authority as sole signatory to handle such investments. The maximum amount to be invested with each asset manager was $400 million. The IO executives were in a meeting at the time when the resolution was sent to us. None of us had instructed the company secretary to draft such resolution. I had no prior knowledge of such resolution and was surprised by the email. Hardy responded to the email requesting clarity on the resolution. The resolution was never signed.
Did anybody receive clarification on this resolution drafted by the company secretary without knowledge of any of the executives?
I'm not sure I understand the question, Mr. Commissioner.
Did the company secretary clarify this? Why did she send out this resolution without a decision by the executives?
I don't recall, Mr. Commissioner. I can't recall whether she responded. The board eventually approved this investment of $1.5 billion in the board meeting of 7 November 2018. As a result thereof, an amount of $400 million was invested with Three Laws Capital in November 2018, and in December 2018, an amount of $400 million was invested with Oasis Asset Managers. As I understand, all amounts invested with Three Laws Capital have since been repaid with interest and the mandate terminated.
Can you perhaps assist the Commission by telling who is Oasis Asset Managers?
Mr. Commissioner, Oasis Asset Managers is, as I understand it, an independent asset manager, not related to the Sekunjalo group of companies.
And we do have the full list of where the $1.5 billion was invested in previous documents. Edward Libber.
That's correct, Mr. Commissioner.
Post-February 2018, I was requested to present to Abdullah a copy of the IO draft interim results. Abdullah was at the time still a board member of IO. I met with him on the 26th of April 2018 at his home, where he scrutinized the gross profit and operating expense margins. I presented to him an Excel version of the results as prepared by the IO finance team. At this point, IO's profit after tax PAT was 32 million. He queried why the margins were so low, as he was expecting a higher profitability, and asked me to adjust the spreadsheet to reflect the usual margins to show him what the effect on PAT would then be. I adjusted the gross profit margin to align to the 35% of prior years, and this increased PAT to 50 million rand. I confirmed that I had sent a screenshot of the Excel spreadsheet to the IO executives, which I understand Hardy has presented into evidence.
If I could just ask you about that 35%. Given the issues that are being raised here as a usual margin, was that a real number, or was it something that was just determined at that point in time as well, so that you had a particular prior year's profit margin set at 35%? Was that real in itself, or just also manipulated to give you an outcome?
Mr. Commissioner, at that point, what we had done was we looked at the prior year to see what the gross profit margin ordinarily would be, and we applied that same percentage to see what the outcome would be. The intention at that point was just to see what profitability would be if we normalized the margin.
But why would you normalize a margin to something that's not real? And is the 35% itself, was that, what I'm asking was the 35%, was that real? Or had that been normalized as well?
No, Mr. Commissioner, 35% is our usual margin. That's what we normally achieve in our businesses.
So your norm and what you would see as regular profit margin would be 35%?
That's correct, Mr. Commissioner.
I don't know what the norm would be in relation to other companies, but that seems pretty high, but there we go. Let that be as it is. Therefore, your understanding of this would be just to indicate what the differential would have been, and that would have been 18 million rand.
That's correct, Mr. Commissioner.
If I read this correctly, or as I'm reading it, it's not whether I read it correctly, as I'm reading it, you did not intend that to be a manipulation. It was for information.
That's correct, Mr. Commissioner.
Just a question there too, is that why was the margin lower, and what was the margin? What was the real margin? Because a margin is just a margin. You just have to report it,
That's correct.
Yeah.
At that point, Mr. Commissioner, I think the margin was about 30%. I can't recall what was the other question you asked, Mr. Commissioner.
Why was the margin lower than the 35%? 30 is not bad, but why was lower?
Yes. Mr. Commissioner,
Lower.
Mr. Commissioner, at that point, the intention was then that an investigation should be done to establish exactly those reasons.
Was such an investigation done?
As I understand it, yes. If I can maybe read the next two paragraphs. Because I was about to go to PE on the 27th of April, as my dad's health had deteriorated, Abdullah requested that I hand over this exercise to Sali for completion. I emailed Sali the Excel spreadsheet that Abdullah and I had worked on and left. I was distracted from my work by having to deal with my dad's illness, which had worsened dramatically. Even though I had been copied in on emails and was kept updated in relation to this issue, I must concede that I was not properly focused on the issue. My dad passed away on the 10th of May, 2018, and I returned to Cape Town on or about the 15th of May, 2018. The SENS announcement was released on the 15th of May, 2018.
Can I just go back to 46? I understand that you took a screenshot of the Excel spreadsheet, which you then sent to the AO executives. Was it perhaps because you felt uncomfortable what was happening with Mr. Abdullah at his home?
Yes, Mr. Commissioner, I was uncomfortable. I wasn't sure at that point what the intention was. In response to the question about whether BDO...
Sorry, are you still not sure now what the intention was?
Mr. Commissioner, the JSC has now subsequently requested that those results be reviewed and audited. So we await the outcome of that investigation. In response to the question about whether BDO has rotated their audit partners in dealing with the IO audit, I wish to state that the audit partners were rotated as appears from what appears here under. In 2015, Imtiaz Hashim. For 2016 and 17 was Bernard van der Walt. And in 2018, Stefan Celia. In response to the statement that the 2018 IO annual report shows that IO showed profitable results and the question whether this was mainly due to the interest earned on share proceeds and if this was excluded, would IO be loss-making? I respond as follows. In the financial statements, the profit before tax amounts to 195.997 million, and the interest is reflected as 225.200 million. Once the interest is added back, the company appears to have made a loss of 29.203 million. In short, I agree that IO showed profitable results mainly due to the interest earned on share proceeds, and if this was excluded, IO would be loss-making. There are various once-off costs amounting to 27.836 million also included in the profit before tax number and mainly attributable to the listing. It is also important to note that IO is in the growth phase and therefore investing in staff and other costs for growth. As at the date of listing and
Just a question on the once-off costs. What would those be?
Mr. Commissioner, the once-off costs are made up of an IFRS 2 adjustment which relates to the BEE consortium share issue.
Mm-hmm.
There are some provision for warranties in there.
Okay.
And I can't really recall what else makes up
others.
that amount, but it is in the financial statements.
Okay. And I guess we'll know soon what BDO says about these figures, isn't it?
About the interim results, this is the 2018 results, August results, Mr. Commissioner.
The annual results, yeah.
That's correct, Mr. Commissioner.
These ones, okay.
So, Mr. Commissioner, these numbers are audited and are available on our website.
Oh, all right. Okay, no, it's fine then, yeah. Okay.
As at the date of listing and as disclosed in the PLS, IO owed an amount of 80 million to AEI. This amount was repaid to AEI using funds generated from the listing.
And that would be in contravention of the conditions set by the PIC?
May I read the next two paragraphs, Mr. Commissioner? On the 20th of December 2017, I was copied into an email sent by Mr. Victor Siani, the Assistant Portfolio Manager at the PIC, to Sali, in which Siani states the following. We just concluded a committee on IO. The committee believes that the issue price is very high, and as such, we require downside protection in the form of a put option to protect PIC's clients against a share price decline, a commitment that IO will spend the equity funds raised only on acquisitions and within 24 months. Shareholder approval for all acquisitions other than BT that are greater in value than 10% of IO's market capital.
Just
Sorry,
for the
Advocate
record,
Libber, just for clarity, in our previous discussions around IO, by the 20th of December, the money had already been transferred to IO?
no, that's not correct.
Yeah?
You will
When did the
recall-
money flow?
You will recall that there was not enough funds
Correct.
to pay for the shares. It was paid in two tranches.
So
So
there
on the 20th is the day before the listing.
Okay.
Only the put option forms part of the downside protection agreement between AEI Corporate Finance and the PIC. The other conditions were never incorporated into the DPA. I was not involved in the negotiations of the DPA, which was between AEI Corporate Finance and the PIC. In response to the question whether share proceeds were only used for acquisitions for growth and within 24 months, my response is that share proceeds were also used to repay the AEI loan. IO has made the following acquisitions since listing. 55% of Seasware Africa IT Group via ZaloServe at a purchase price of 165 million. 40% of Saab Grintech Technologies, SGT via Main Street at a purchase price of 100 million. 24% of Global Command and Control Technologies, R1 for the equity and a term loan of 15 million rand. 32% of Vunani Group, 145 million rand preference share, and 50% into a Vunani FinTech fund at 100 million rand.
So just for clarity there, that is roughly 500 million of the 4.3 billion raised.
That's correct, Mr. Commissioner.
And was this done in 2018? Has there been sort of, just not necessarily the months, but at least the question of 2018, 2019, 2019, when were these transactions conducted?
These acquisitions were done towards the end of the second half of 2018 and the beginning of 2019, Mr. Commissioner.
And again, related party? Are any of these already related parties or had an investment from any of the second Jala group? Do you know?
I'm not sure, Mr. Commissioner. The only one that I am aware of is Seasway, where Reverend Mahana was a shareholder of Seasway and also a director of AEI, but Reverend Mahana was not a director of IO. I'm not sure of the relationship with the others. To my knowledge, there is no related party relationship.
Can we check that, Advocate Libber, to
It's
just
noted,
see whether, not necessarily to IO, but to any entity within the group?
Thank you, Mr. Commissioner. It is noted. Can you just deal also with the 32% Vunani Group, 145 million preference share? If my memory doesn't fail me, there was evidence that this was in fact a bailout for the debt owed to Investec by the Vunani Group. Is that correct?
That's correct, Mr. Commissioner.
Can you just elaborate on that a little bit?
I'm not sure of the detail, Mr. Commissioner, but I am aware that Vunani owed, there was a loan between Vunani and Investec at the time when IO purchased the shares.
Okay, a question here. If I can sort of recall that there was a criteria on how to buy these companies, that they would have warranties, were this done according to the criteria which you guys put out?
Yes, Mr. Commissioner, that's my understanding, that they were done according to that criteria. And some of them do have warranties in place. In regard to the question about whether IO implemented a conflict of interest policy, I wish to state that such policy was in the process of being drafted when I last checked in January 2019. I understand that the policy has in the meantime been drafted, but I'm unsure as to whether it has been approved by the board or issued to the PIC. As far as the composition of the IO board is concerned, I understand that the board appointments and nominations rest with the nominations committee of IO. The only knowledge that I have...
do you know who are the people on this nomination committee?
I can't recall, Mr. Commissioner. I would need to check that.
We will follow that up and provide the information to the Commission, Mr. Commissioner.
The only knowledge that I have in relation to the nominations requested by the PIC is a board nomination received by myself from the PIC in respect of Advocate Ramatlodi on the 27th of February 2018. He was subsequently appointed on the 7th of March 2018. I'm not aware of which other board members were appointed by the PIC, as I did not serve on the nominations committee.
Just to get it clear, that Advocate Ramatlodi was nominated by the PIC to serve on the board.
That's correct, Mr. Commissioner. Since my appointment as CFO of IO, I, over a period of time, became concerned about certain corporate governance issues in the business. These concerns were ultimately presented to the board of IO in a letter dated 7 August 2018, a copy of which I attach as Annexure NG4. I pause to mention that as soon...
Where is that? Let's just see. Where Annexure 4, NG4.
Is that the same letter that was presented in his evidence by Mr. Hardy?
I
Yes.
believe that it is, Mr. Commissioner.
Okay, to Mr. Salim Young, isn't it? Yeah?
That's correct, Mr. Commissioner.
All right, so you put out all the concerns here. All right,
That's correct, Mr. Commissioner.
okay.
I pause to mention that I soon realized that the role of CFO placed huge responsibility on me, bearing in mind that I had a very young child. I also felt overwhelmed by being the CFO of a listed group, which carried much more responsibility than being a director of an unlisted company. At the end of July 2018, I had discussions with Abdullah and informed him of my intention to resign and that I wanted to leave at the end of August. Abdullah pleaded with me to reconsider. At the time, Hardy and Nodwele had also indicated to me that they were not happy with the corporate governance breaches and that they wanted to resign. I told Abdullah about this. I did not tell Hardy and Nodwele about my intention to resign at that time, as Abdullah had told me that if I did so, that they may also wish to resign. I felt that if all three executives resigned, that it would have severe consequences for IO. Over this period, there were ongoing discussions between myself, Hardy, and Nodwele around the corporate governance issues that are contained in the aforesaid letter. Nodwele felt very strongly that we should present a joint letter to the IO board in which our concerns are set out. Myself and Hardy agreed with this. It was important for me that the board addressed our concerns in a constructive manner so that IO could deliver on the undertakings that IO had made in its PLS. We agreed that we would present our letter to the board at a meeting which was to be held on the 7th of August 2018. Salim Young was advised about our intention to present the letter to the board, and he requested that we meet with him in the morning prior to the board meeting at the Vineyard Hotel to discuss the letter. At this meeting, we presented the letter to Young and also verbalized what was contained in the letter. Young undertook and agreed that he would present our concerns to the board at the meeting scheduled for later that same day. Young had sight of the contents of the letter and, as far as I can recall, was given a copy thereof. At the board meeting, Young advised the board that he had received a letter setting out certain concerns raised by ourselves in relation to corporate governance issues. He advised the board that he did not intend to read the whole of the contents of the letter to the board and that he would address certain main concerns, which he then did, and undertook to circulate a copy of the letter to the board. On Sunday, the 19th of August, Hardy, Nodwele, and myself had a conference call. They informed me that it was their intention to resign if the concerns raised in our letter were not addressed and or resolved. They did not give an indication of when they intended to resign. In the discussions, they suggested that I should also consider resigning. I told them that I did not think it was the right thing for all of us to resign together and said that we should each decide for ourselves what we wanted to do. I particularly appealed to Hardy to reconsider his intention to resign and pointed out to him what great staff we had recruited, particularly staff who had transitioned from BTSA to IO when we were awarded the Sasol contract. I further informed them of the consequences to the business if all the IO executives resigned at the same time and that we had staff to whom we had a responsibility to as leadership. I was under the impression that they were considering the way forward, but was then shocked and surprised when I learned that they had both resigned on the 23rd of August 2018. After the resignation of Hardy and Nodwele, Abdullah approached me and requested that I assume the role of CEO. I agreed to assist in this capacity with the understanding that he would recruit a new CEO and CFO, and I indicated that I no longer wanted to remain on the board of IO and or be the CFO. He agreed, and as previously stated, I resigned from the board in January 2019.
Thank you. Can I just, before we conclude, ask you a couple of questions? You have listened to the evidence of Hardy and to Nodwele, and you have seen their written statements.
Mr. Commissioner, I've listened to Kevin Hardy, but not Nodwele.
Right. But you've seen Nodwele's statement.
I haven't actually read it, Mr. Commissioner.
Right. Where Hardy talks about you and your role and involvement, are you in agreement with his evidence or do you disagree with his evidence?
Mr. Commissioner, I think I can't recall everything he said, but on the balance of it, I think I do agree with his evidence, Mr. Commissioner.
Okay. Then there is the evidence, there was this evidence of Hardy about recordings made of 2 board meetings. that correct?
I only recall the one board meeting, Mr. Commissioner, on the 7th of August.
Right. Is it correct? Well, there was also a recording of a meeting after the board meeting.
That's correct, Mr. Commissioner.
So there are two recordings.
That's correct, Mr. Commissioner.
And is it correct that you made those recordings?
Mr. Commissioner, I made those recordings at the request of Kevin Hardy.
And have you seen the transcription of those recordings?
I have not seen the transcription, Mr. Commissioner.
In his evidence before this commission, Mr. Hardy testified about Dr. Survey at the meeting after the board meeting, trying to persuade him to call the PIC, in particular Mr. Fidelis Madavu, to convince the PIC that the BTSA deal is still on track. Can you recall that conversation?
I do recall that conversation, Mr. Commissioner.
According to Mr. Hardy, he was in fact requested by Dr. Survey to tell a lie to the PIC and to calm them prior to the listing. I've asked you this question this morning, and your reply to that is that the Commission should look at the transcription of the meeting, which is speaking for itself. Is that your answer?
That's correct, Mr. Commissioner.
That is the evidence. Thank you, Mr. Commissioner.
You are at IO at the moment. What's your feeling about the future of that company without BTSA in general? I mean, looking forward 2-3 years out.
Mr. Commissioner, IO and BTSA still do have an alliance agreement in place, and they are still working together on the SASOL contract. I'm not sure about the future of IO, since we've obviously been slowed down significantly with all the negative media reports, etc. We have an amazing team of people, managers, etc. And if I look back to the past few months at the pipeline of acquisitions, the customers we had lined up, etc., if not for all the negative media reports, I think we probably would have achieved the targets set out in our PLS. But at this point, I'm not sure what the future holds for IO.
Okay, thank you.
Ms. Hamaldin, you've been subpoenaed before this committee, and I would ask you, and obviously you don't need to reply, but what is do you have any concerns about your own situation in IO, and whether there will be any repercussions to you from appearing before this committee?
Mr. Commissioner, I'd prefer not to answer that question, if that's okay.
If I can be of assistance, is it correct that you were requested by people in IO or Sekunyalo to meet with their lawyers, Mr. Abrams, to prepare a statement before you appear before this commission?
That's correct, Mr. Commissioner. I was requested to meet with their lawyers. However, I declined and chose to use my own representation.
And there must be an obvious reason for that, but I understand if you don't want to talk to the Commission about that. But
Thank you.
Mr. Lube, just a question from my side, if you can clarify that if someone is subpoenaed to come and present to the commission, can there be any repercussions for them, if any? Can
Yes,
they be victimized and all that? Because
unfortunately, yes, Mr. Commissioner, that can happen. The only protection for the witness is in the labor relations legislation, which is unfortunately not a complete protection. So yes, and I think I need to place it on record, this witness came to this commission under a subpoena, under huge stress, and in all probability, there will be repercussions for her after her evidence before this commission today. Unfortunately, I or the commission cannot guarantee that nothing will happen to her. That is unfortunately the situation.
Except that we can say that it would be most unfortunate if there was to be any repercussions for you appearing here, because first of all, we have subpoenaed you, and second of all, this is a commission of inquiry to see whether there was any impropriety committed by the PIC and what the issues were around that. And you have presented, as far as I can see, your honest opinion of what happened in relation to the IO transaction, which should be visible for whoever's an investor in IO or any of the second Jala group. So I think it would be something that we would, perhaps Advocate Libber through you, just keep an eye and see whether there is any repercussion, but I think it would be most unfortunate.
Thank you, Mr. Commissioner. It's appreciated. And I think that what must be added to your comment is that you will recall that Dr. Survey, at the conclusion of his evidence, if I recall correctly, told the Commission that he is prepared to fully cooperate with the Commission in the work of the Commission, and if necessary, he will come back to the Commission if there's a need for that. And in the light of that attitude, it would be most unfortunate if there's any action taken against this witness after she came here under a subpoena and just gave her evidence based on the facts to her disposal.
But perhaps in terms of concluding the record of this particular witness, it would be useful to look at the testimony of Dr. Survey, because if I recall, and I don't have it in front of me at the moment, but if I recall, he actually said words to the effect that the IO transaction he had nothing to do with the IO transaction, it was handled by the team dealing with IO, and that his team was available to appear before this commission and to ask them any questions. And if I remember correctly, he actually specifically mentioned Mr. Sali as a person who was dealing with much of it and would be available to talk to the commission.
You are absolutely correct, and you will recall that he in fact looked back to the people behind him and said, here's my very competent team, and Mr. Sali was in fact sitting that morning in the commission.
Therefore, none of those witnesses, none of those people being asked to come to the commission should be afraid of any repercussions or victimization, as this was at the direct request and, if you like, a recommendation by Dr. Survey about questioning or talking to his team. And I think that should be placed on record.
Thank you. It's noted, Mr. Commissioner.
But Mrs. Hamaldine was not here when Dr. Survey...
She was not present that day in Dr. Survey's team sitting behind him. That's quite correct.
Perhaps we should put some kind of protection, you know, for witnesses in the Commissions Act, but that's a separate matter, I guess.
The gentleman sitting behind you?
That is the witness' husband, giving support to the
Yes, I thought that was the husband. Thank you very much, sir. You may be seated. Yes, I just want to thank you on behalf of the Commission, Mrs. Hamaldine, for availing yourself to come here. All we can say is that hopefully nothing untoward will happen to you. It is correct that Dr. Survey offered some of his, call it, employees who were here, and I would assume that you wouldn't have any objection really to anyone else in the companies to be called to come and testify before us. We thank you for coming, and please get in touch with Advocate Libber if anything were to happen, so that we could see what we can do. Okay.
Thank you, Mr. Commissioner.
Thank you very much.
Mr. Commissioner, this is the business for the day. There's an Easter weekend ahead of us, so we'll have to adjourn then until Tuesday. That is the 23rd of April at 10 o'clock.
At 9:30.
At 9:30, you absolutely, you reminded me now. That was the agreement with the legal team of Harroth. That's quite
Yes,
correct.
yes. And everybody enjoy your Easter weekend
Drive safe.
and drive safely and come back fresh on the 23rd. We adjourn until the 23rd at 9:30.
Everything.